This is Julio Zamora. Today, December 3rd, 2012. On December 7th, 2010, I was flat out sent home. Just flat out sent home. On December 6th, 2010, my logs were perfect. They were perfect. I had 2 minutes left, and then I took 10 hours off from the onboard automatic recording device. Okay, that's which we get paid for by a trip sheet. Okay, on December 6th, 2010, the dispatcher took my logs and changed the time on my logs, matching the time on the data machine in the driver's room, which you have to punch in even though you're on duty when you get on the property. So I lost 45 minutes on my time card or trip sheet. Okay, and by doing so, he falsified my logs. He's not allowed to touch them logs. The onboard automatic recording device that prints out logs in an algorithm sheet. Okay, and the automatic onboard recording device was put in there by the federal government for me and 400 truck drivers not to be able to falsify anything. That was their intent. Okay, and so anyway, the dispatcher changed the law, took the time from the data machine in the driver's room, then changed in time on the automatic onboard recording device, which is not allowed to do so. That's falsifying logs. And he didn't write anything down in the remarks section, which is required to do, and I'm to sign to be true and correct. And nothing was written, and I didn't sign anything. Okay, and I should note this statement is for Judge Grill's court. Okay, for on-the-job injury on 3/21/2009, and the fact that my disability benefits and payments and everything were denied or canceled on 4/17/2009 because of a PR2 report that was made out and completely left out all information and documents from on-the-job injury report, occupational report made out by the Los Banos Memorial Hospital. It was completely ignored, and it wasn't in the report, in the PR2 report. And the company doctor was notified that I was in the hospital, and that I went in there left leg pain, the same thing I saw Nancy Perdillo for on 3/21/2009. She's an alcohol and drug technician. And I never seen the doctor or any x-rays. I had a follow-up with Dr. Hubby. I gave her a copy of the MRI, and she proceeded to send it into Safeway to get an approval for Dr. Baby to fix the pinched nerve. Okay, that the hospital suggested, which I had referrals, and etc., etc. And there was no reply, other than the fact that the reply was denying me my benefits and payment, and that I owed them $3,000, and that they want me to pay the unemployment office because they said they're in conflict of liability. They don't have a right to decide anything, and I sent them a full release to go back to work, which they was refused by Safeway. Now, I've been on disability payments or unemployment payments from the Department of Unemployment Department of Unemployment Office. Okay, they've been taking care of me since 4/17/2009. Conflict of liability. They don't have a right to decide anything. They need to return their money from 4/17 to 2012, and this is December 3rd, 2012. And they sent me another conflict of liability because I sent them the release to go back to work, and among other documents, to establish the fact that I should be working. So they're going to continue my payments. Okay, so that being said, Nancy Perdillo gave the wrong diagnosis on 3/21/2009, and they denied me everything. I went to Dr. Baby's office, and they said it's against the law to use my insurance, TEAMSTERS insurance, okay, or Medicare, okay. That's what they said, and I didn't know anything about no law about if you get denied everything and you have no way of insurance or anything, that you can't get fixed. It just says you can't use your insurance if it's a workman's comp issue. So that's all I know. So anyway, I went back later on and saw Dr. Baby on my own, and I used Medicare and Teamster insurance. Because I needed treatment and everything, and they wouldn't give it to me. And Safeway accused me of, by the PR2 report, that there was nothing wrong with me. They're not telling the truth. They're in a state of denial. They did not reflect the occupation report from the Los Banos Memorial Hospital. And that's where that is with the workman comp issue with Judge Grill. I hope he understands that. And that I filed harassment 3132As in severe profound hearing impairment, in which Judge Grill had to order Adam Stewart to get me a legal document because I presented him a document from a qualified medical doctor that I have a severe profound hearing impairment, but it wasn't a legal document, so Judge Grill ordered the lawyers to get me a legal document. That's how we came to that. Now, I'm still not back to work. I was supposed to have been returned to work 3 or 4 times, and they refused to do so. Once by the administrative judge suggested for them to put me back to work. He didn't do it. Once by the union, on December 17th, they denied the discharge to put me back to work with all back pay and benefits because they did not respond on December 25th with documents, photos, etc., to prove their case beyond a reasonable doubt. And on top of that, worst of all, they never sent me any registered mail that I was ever discharged or anything else in the year of 2010 because the time limits weren't met. They didn't produce any documents. They didn't meet the time limit. They didn't follow contractual procedures. End of story. So they were supposed to put me back to work like they do for 1,500 other Teamsters. If it's not, if they don't reply within 10 days, it's null and void, final and binding. They didn't do so, so we don't need to go any further. But I should know one thing for the record, that Mr. Neiswanger sent denial of discharge to the transportation manager, James Williams, to set a date and time for a hearing, and it was set for January 11, 2011. January 11, 2011, and on January 10, 2011, I had a meeting with the union with Mr. Neiswanger, and that was the first I heard of anything, and I didn't accept any documents. And I didn't say nothing at the hearing for the fact that I have a severe profound hearing impairment, and the union put it in caucus and said that if you need hearing aids, we'll look into it, and so we'll put the meeting in abyss until then, or whatever. But there was a debate, and they just sent me home. Flat out sent me home like they did on December 7, 2010. They just flat out sent me home, and the meeting was an abyss. Now, I don't know any more than that after that, but the fact I should remind the Judge Grill that I was never notified. There was no communication between me and Safeway. And I have a letter document filed by Mr. Mike Sadler, the safety manager. Agreement was filed. It was email fax December 17, 2010. On the left-hand side, he's supposed to put down the names and everything, who he sent registered mail to, that the discharge took place, but it was denied by Mr. Neiswanger on December 17, 2010. He didn't notify anybody, and he didn't notify me, so the discussion was just between the Teamsters and Safeway. Me, Julio Zamora, had no discussion with Safeway or the union until January 10, 2011, or January 11, 2011, according to the meeting set by James Williams, the transportation manager. And I should note that's not within 10 days. And I should also note they missed all the time limits. And they didn't prove anything beyond a reasonable doubt. I was completely ignored, and I was not involved in any discussion whatsoever with Safeway and the union. And the first time I met them was in January 11, 2011. Okay, and they didn't put me to work. And they didn't put me to work, administrative judge. They didn't put me to work when the notice of offer of work was sent for the second time for me to fill it out and send it in. And that's for the time and date and shift that I wanted at 14 hours a day. Eureka run at 10:30 in the morning. Okay, I signed it, sent it registered mail. My union, Modesto Legal Clinic attorney said to report to work. I guess that was the third or fourth time. Administrative judge, an attorney, and the union. 3 times. And they violated the contract, work first, grieve later on December 7, 2010. And I should note that they found me guilty before I even had a hearing or had anything to say. They just found me guilty, so they'd send me home and violated the contract because they assumed that I falsified something and I didn't do it. So by their assumption, and they're wrong, I should get paid the back pay from December 7, 2010. 14 hours a day until I'm returned to work. There's no doubt about it. And all back pay and benefits, and I need a court order for it in order to happen because of the fact in 2009 they took me off work, put me on, took me off, put me on, no grievance, no arbitration, no nothing. And I was off almost 4 to 6 months, and I never got any payment, back pay, benefits, pension, and my lifetime medical was not paid into, like it has been for almost 10 years. So they just ripped me off in 2009. So, and in December 2010, they flat out sent me home and didn't let me log out. So we know all of that, and that's it. That's all there is. So I'm asking Judge Grill to return me to work with automatic retirement on September 7, 2013. September 7, 2013, and I should get a court order for all back pay and benefits and lifetime medical, which only becomes active when you retire. So give me September 7, 2010 automatic retirement. That way I have my lifetime medical for my family and my son's in the Air Force. In case something happens, we have it. So I guess that covers everything. There's no need to any more to be said because the PR2 report was a debacle. They didn't include the occupational report from the Los Banos Memorial Hospital. It wasn't added on. Nothing was mentioned. It was assumed that something else was wrong with me. And the fact that I saw this doctor twice that day, once at 1:15 p.m. and the other one at 12 o'clock in the morning. Now, I'm not going to go into that. But he made one statement, I'm not sure, and the other statement, I don't think it was a job, whatever it was, job related, but he didn't state that the low back wasn't job related. He just said, I think there's something else wrong with him, and didn't take the occupational report into, he didn't mention it, okay? He didn't take it the fact that he just didn't accept anything Los Banos Memorial Hospital said, and he just ignored it. So it made it appear that I did something wrong. And Mrs. Esperanza or Miss Esperanza from Phoenix, Arizona, denied me everything. So that's where it stands right now. So that's why I need a court order and to be returned to work immediately. And I'm sitting at home on call because of the dispatcher's actions. Okay, he took 45 minutes away. He took off my time card, and I lost a day's pay, and I have no log to show my hours, and I can't get unemployment because of his false accusations. And he's working, and I'm not. So that's it, and I need the money to be paid to the unemployment office. And also, I would like the judge to correct that I owe Safeway Insurance Company $3,000. I don't owe them anything. Okay, they should have been paying me this whole time, and they didn't pay me 1 cent. They just take. Okay, and they haven't paid the Social Security office. They haven't paid unemployment. They haven't paid Medicare, and they haven't paid the Teamsters insurance, let alone myself. And I should note that if it's not within 10 days, 1,500 Teamster truck drivers are put back to work with all paid back pay and benefits, as well as myself. Okay, and I'm not going to get into the double standards, but I invoke double standards. I invoke double standards. Life is not fair to be returned to work. Mollify double standards. Life is not fair. So this is Julio Zamora, an employee for Safeway in 2002, and I'm still an employee because of the fact that I was never informed. And that I'm on call waiting for dispatch because they didn't allow me to log out or clock out. And the shop steward can testify to that he escorted me to the property. So the clock is ticking. They owe me 14 hours a day, and there's work available according to the notice of offer of work that I filled out and sent back registered mail. They need to pay me every day at 14 hours a day according to the contract. If anybody works underneath me in seniority, they need to pay me for every day that somebody works underneath me, and it's a 24-hour operation. We're working around the clock, and I have almost 200 employees underneath me in seniority. 200 employees underneath me in seniority. Now, if the 1,500 other employees are returned to work, why not Julio Zamora? And why is the dispatcher working and not me? So that's it. I hope Judge Gross considers that. I invoke double standards. Life is not fair. This is Julio Zamora, 1385 El Camino Way, Los Banos, California. 209-829-1787. And I'm going to put this on the internet, and I'm going to make another update, another recording. I had a dream, so I made this tape, and that's it. Everybody enjoy their Christmas, Merry Christmas, and all I want for Christmas is to be returned to work in the interest of justice. In the interest of justice, I should be returned to work before Christmas. For Christ's sake, it's going to be the third Christmas. What's holding this thing up? I don't know. And the union sent it to arbitration. They denied me arbitration. Why? They said they couldn't win this case. How could they not win this case? For Christ's sake, they didn't meet any time limits. I was never informed, never received any registered mail. How can not? If they get away with this with me, what about the 1,500 other Teamsters? How do you know they're not going to do it to them? Just slam them home. Hey, you got to reply in 10 days. I'll forget you. Go home. Hey, well, that's what they did to me. 1,500 Teamsters. They can throw them out anytime they want. So I need to be returned to work. And Judge Grill, I hope he understands this. They violated contractual procedure. They violated company policy because 1,500 or 400 truck drivers in Tracy, California Distribution Center are instructed when they had the the manual from Safeway when you're hired, and it states you will. 400 truck drivers myself, you will follow the Department of Transportation and the contract. You will follow the Department of Transportation. So, end of story. I'm innocent. Merry Christmas, and I hope I need public support on this. I don't know how. Safeway is in Tracy, California Distribution Center. They got 400 truck drivers there and 1,500 Teamsters. And Local 439 in Stockton, California, why they haven't taken any action, because I've been there 2 or 3 times, and Mr. Neishunger hasn't done nothing, even though he knows I was not involved in any discussion. And they didn't meet the time limits. And they didn't work me first and grieve later. And they didn't present anything. But yet, he didn't make any effort to put me back to work when the discharge was denied on December 17, 2010. Now, they put 1,500 other teachers back to work. Why not me? The union attorney said I was fired on December 16th, but it was denied on December 17th, and that was it. Nothing was done, flat out. My union attorney Modesto legal clinic said, attorney said, go to work, report to work, Esperanza, notice of offer of work, good for 1 year. I'm guaranteed that, right? I give it to Neishunger. He doesn't do nothing, right? My attorney said, put him to, go to work, check into work. I did. I see Neishunger. What did he do? Nothing. Oh, there's nothing. We just first I heard of it. First he heard of everything. Okay, well, that's fine. I'm just saying that for Judge Grill Court. I hope he considers giving me a court order for my back pay and to reinstate my my RSVP, which is separate from the health and welfare lifetime medical report. Okay, end of story.